Number 6 on the docket, People versus Bobby Cunningham, 22147 FH.
Lieutenant for the people.
Is Mr. Cunningham present?
Cunningham present, visa soon.
All right, today is a pretrial, Mr. Cunningham. Are you in talks with the prosecutor about a resolution, or would you like a trial date?
Basically, I was asking if I can actually adjourn it. Maybe the prosecutor wants to send some other documents. I have not had any communication with the prosecutor as well, for the record. Excuse me. From my understanding, as me represent myself, from my understanding, under the U.S. Constitution, I have a protected right under the Sixth Amendment of due process, which basically, under due process, I wouldn't be getting due process if I wouldn't question the original witness. In this case, excuse me, ma'am, is it possible that we can both come to the bench?
All right, I'll have a bench conference.
Yes, ma'am.
Back on the record.
All right, go ahead, Mr. Cunningham.
Okay, for the record, my understanding of the U.S. Constitution running concurrent and parallel to the Michigan Constitution, I have a right to due process under the Sixth Amendment law of the Constitution. From there, one, I didn't get to question the original witness. Which basically what they do in this case is stated. Me personally, I'm asking for a mistrial or a dismissal. Under those circulations of the documents that you do have in your hand, and also what was sent to me from the prosecuting office October before, quote unquote, a backdated amendment, which basically wasn't a motion heard on, which still materials that I asked for, I still didn't have, such as the transcripts and the videos, to better circulate and get other references to for my court case. And it also will be a poisonous fruit of law. Go ahead, Mel. Excuse me. For the record.
Right, Mr. Cunningham, I have a hard time following you and following what you're asking for. And I've had the same problem in the past several hearings as well.
Yes, ma'am.
Today's a pretrial. It's not scheduled as a motion hearing. And what I'm going to do is require that you put your motion in writing and file it with the court so that I can consider it and try to follow the arguments that you're making, and that I can give them the consideration that they deserve. So if there's nothing else, and I'm not hearing anything that I feel that I can handle right now from the bench without having it in writing, I'm going to schedule a jury trial. And that doesn't stop you from filing any motion that you want, but it just puts the case on track to head to trial.
All right. Your Honor, just two things I would like to just place on the record here. Is that one, if the court prior to setting the trial or jury trial in this matter, if we could just, again, because this is the start of another proceeding, just advise Mr. Cunningham of his right to counsel and the cautions for one in representing themselves. And then also just to advise Mr. Cunningham that if you would like to discuss resolving the case, but not the merits thereof, as you have rights, and talking to me about the subject matter of the case may interfere with those rights. But if you would like to discuss resolving the case, please feel free to either call my office or send me an email, whichever one is your pleasure, as far as your method of communication, and I would be happy to discuss an offer in this case and resolving this short of a trial, if that is your desire, sir.
No, that would not be my desire. Once again, on your witness list, since this is a pre-trial, can you tell me on your witness list, you have not kept in communication with me, you have not sent any documents that basically, I only know of your witness list because of certain texts that was sent to me, sir. You have not been keeping in compliance to me to basically update me on your witness list. I've been trying to update you on your witness list. Last motion, I stated that basically it was not on your witness list. You have not even addressed that. I mean, you talking to the courts. Excuse me. You're talking to the court.
Mr. Cunningham,
To still have
this is something you can bring up by way
your
of motion.
witness for what?
Mr. Danner, is September
How long do I
19
have,
an acceptable trial date to you?
I'm sorry, Your Honor, I didn't catch that date.
September 19 for jury trial?
September 19th, Your Honor. Yes, Your Honor, September 19th would be a, let's see here. Yeah, I believe there's only one other trial scheduled on that date in which I am looking to resolve. So the 19th would work, Your Honor.
All right, and Mr. Cunningham, is September 19 acceptable to you?
That was due, but I have other prior engagements other than, not to be rude, other than staying in Ann Arbor. If you can see some of the documents, state Kentucky. I was never, which the complaints say, which the complaints say homeless, which basically I had a whole address
Was that
in
a simple
Kentucky.
no, that date is not good for you?
No, ma'am. Somewhere around December
Okay.
would be.
Thank you. October 3. How's that?
Can you put it like around the 19th or the middle of the month?
I can't, I'm out in the middle of the month.
All right,
Is October 3
it is.
acceptable?
Yes, ma'am. It will have to do, ma'am.
Mr. Danner?
Yes, Your Honor, that
anyway,
would work for the people, Your Honor.
Okay, and then final pretrial, September 13.
All right, yes, ma'am. Lou Dane, if possible, could you send your information to my email as well?
I can see
He's
if I
given
have
you
it.
his email address previously, Mr. Cunningham.
Well, basically, if possible, that way we can keep communication. He can put a star on it or highlight it, so therefore he knows when I send him documents or what type of motion I'm trying to move. I have been compliant and also have every motion gave to the prosecutor, and they have not responded, which basically is leading to quote unquote your time and the taxpayers' time as well. So I just give you my email address out in the public right now, UCC 1-3008@writeme.com. You can text me anything you think we can resolve this. You can move it out your day. I can move out my day, sir. Thank you.
Sir, I honestly did not understand that email. I am going to provide you my contact information again, sir.
Okay.
And I would encourage you to please reach out to me in regards to if you have any questions that are not about the merits of the case or to resolve it. I would encourage you, sir, to please reach out to me, and I will provide you my email again. It is my last name, which is on the screen here, DANNER. My first initial L, so it'll be Danner.
Yep.
L.
Was Washington
.org.
.org, exactly.
Yes, sir. And I can give you the number to the main line, and then you can ask for me, and they will direct you right to me. And those calls go right to my cell phone, so I will be able to answer regardless of if I'm in the office or not. Would you like that number, sir?
I can get the number, sir. I've been to the office already several times. I have been compliant. I'm not understanding why the judge, I'm not understanding me being compliant to them, but they're not being the same respect to me.
Mr. Cunningham, I will address a motion when you file it. I want to warn you yet again, as I'm required to, that representing yourself is not a good idea, that you would do very
So
well
are you my
to
advisor,
allow
attorney
yourself
now?
to be represented by an attorney. And I will appoint an attorney
my
to
attorney?
represent you, or I will appoint an attorney to act as standby counsel to you to help you navigate. But if you have the right to represent yourself, if you do that, you are held to the same standard as an attorney, and you're expected to know and understand the court rules and the statutes, and to not smoke in court.
Oh, excuse me. Can I drink water? There's usually no water right there where I can drink it. Is that all right? Or maybe not.
You may drink water. Are you, would you like an attorney or standby counsel, Mr. Cunningham?
No, I just told you, man. No, not at all.
Okay. All right, thank you. We're all set. We'll call the next case.
Number 34 on the docket, People versus Angela Weems, 22-154 FH.
Lou Danner for the people.
Angelo, especially up here.
Sir, would you mind?
Oh, all right.
I'm not going to have you eating an ice cream cone.
All right, I'm
court.
sorry.
Your Honor, I had the opportunity to speak with Mr. Weems yesterday as well as today. Our conversation was cut short yesterday due to him suffering a bit of an injury due to a biking accident. But he did in fact reach out to me again before the docket here, and we discussed the matter, Your Honor, and I had informed Mr. Weems of the offer that the people were willing to make in this case, and have also informed him of the charges as they stand as far as all of the 4 counts alleged in the information. I had informed him of the offer and of a sentence agreement, and then informed him that I would need to make sure that I place the entirety of it on the agreement, on the record, before he makes any acceptance, as I wanted, if he was to accept the offer, for that acceptance to be done on the record, Your Honor. So if I may.
Before you get into that, just 1 second. I know that Mr. Weems is representing himself, but my notes have the public defender as standby counsel.
That is my understanding as well, Your Honor.
All right, Mr. Weems, do you still wish to represent yourself?
Yes, ma'am.
Have you been accepting the help of standby counsel?
Yes, ma'am.
Would you like us to wait until Ms. Noveski can join us in this hearing?
What was Miss Noveski?
She's a public defender?
Oh, well, yeah, please.
Okay, then we'll hold on for just a minute. She's meeting with somebody else in another room. And I'll take this minute to tell you, as I will tell you at every hearing, Mr. Weems, that you're entitled to an attorney. The court will appoint one if you can't afford one, and you would be well served to accept an attorney. You will do better with an attorney, and if you refuse an attorney, you're still held to the same standard as though you were an attorney. That is to know the court rules and the statutes and the case law of the state of Michigan.
Understood.
And we'll just hold on for Ms. Noveski. All right, we're still on the record. Ms. Noveski, we paused for a minute with Mr. Weems because the public defender is standby counsel to Mr. Weems.
Okay, I'm sorry, Your Honor. I
And-
didn't remember that.
No, that's all right. That's all right. And Mr. Danner was about to put an offer on the record. That's as far as we got.
Okay,
Thank you, Your Honor. So the offer I had articulated to Mr. Weems, and I believe I also sent an email to the same effect, except for a little difference in the sentencing agreement portion of this to Ms. Noveski as well, is that Mr. Weems would be, the offer would be for Mr. Weems to plead guilty to count 1 the weapons offense, carrying a concealed weapon. And we would dismiss counts 2, 3, and 4. Further, there would be a sentence agreement to no upfront jail, probationary term of 12 months with the possibility of early discharge if all terms are completed within 6 months. And Mr. Williams, would you like to accept that offer?
Yes, yes. Yes,
Okay.
I heard you. I'm sorry. I'm just getting ready to take the plea. Mr. Williams, raise your right hand. Do you swear or affirm the testimony you'll give will be the truth, the whole truth, and nothing but the truth?
yes, Your Honor.
Mr. Williams, you heard the agreement that, or the offer that was just put on the record. Is that what you would like to do?
Yes, ma'am. Yes, Your Honor.
Count 3, carrying a concealed weapon has a count 1, carrying a concealed weapon has a maximum penalty of 5 years or $2,500. If you plead guilty, you'll give up your right to a jury trial and your right to be presumed innocent until proven guilty beyond a reasonable doubt. You'll give up your right to have witnesses against you appear and to question those witnesses, and your right to compel the appearance of witnesses on your behalf. You'll give up your right to remain silent and not have your silence used against you, and your right to testify on your own behalf if you should decide to do that. Your guilty plea could be a violation of probation or parole, and there could be immigration consequences if you're not a U.S. citizen. If you plead guilty, you will not be able to claim that your plea is the result of threats or promises not disclosed on the record, and you'll have no automatic right to appeal. So your only appeal would be by permission of the Court of Appeals. You'd also not be able to appeal any issues that might arise during trial, since you won't be going to trial. Do you understand these rights, Mr. Weems?
Yes,
Do you want to waive those rights and plead guilty here today?
yes, Your Honor.
You've been threatened or coerced to get you to plead guilty.
No, Your Honor.
Have you been offered anything that wasn't disclosed on the record here today?
No, Your Honor.
Is it your choice to plead guilty?
Yes, Your Honor.
You need a sentence agreement sheet. The allegation is that on January 18 of 2022, you were in the city of Ypsilanti in Washtenaw County at East Michigan Avenue on Miles. Is that true?
Yes,
At that time, did you have a handgun concealed with you in a car?
yes.
And you were driving that car?
I was traveling. Yes,
Are the people satisfied?
Yes, Your Honor.
And the defense?
Yes, Your Honor.
Mr. Weems, are you satisfied?
yes, Your Honor.
I'll accept the guilty plea, find that it's knowingly and willingly made, and we'll schedule sentencing
July 19th.
July 19. Mr. Weems, do you want Ms. Noveski present for your pre-sentence interview?
Yes.
Okay. You need to call probation to schedule your interview. Can you take down the phone number?
Yep, give me 1 second. I'm ready.
734.
73.
Oh,
go ahead.
sorry.
You
222 3390.
Mr. Weems, please call tomorrow to schedule your pre-sentence interview.
Okay.
And that's it. You're all set, sir.
All right, thank you.
Thank you, Your Honor.